I'm Sherrilyn Ifill. I'm the President and Director-Counsel of the NAACP Legal Defense Fund, the oldest civil rights legal organization in the country, founded by Thurgood Marshall in 1940. We are an entirely separate organization from the NAACP and have been since 1957. We began our work fighting on behalf of Black voters and their right to participate equally in the political process in the 1940s. And the first major victory in the Supreme Court won by Thurgood Marshall was his case Smith versus Allwright in 1944, in which the Supreme Court struck down the use of all-white primary elections in the South. LDF represented the Selma Marchers in 1965, working with John Lewis and Hosea Williams and Martin Luther King and many others to help plan the route after that encounter with state troopers on the Edmund Pettus Bridge and representing the Selma Marchers through the final Selma to Montgomery March. When Americans saw what happened on the Edmund Pettus Bridge that year, that Sunday night, they recognized that what they saw, the brutal attacks on Black individuals marching for the right to vote, was a threat to our democracy. Americans, Black and white, Republican and Democrat, understood that this was not the America they wanted to be associated with. They understood that the brutal beatings on the Edmund Pettus Bridge defiled the image of this country and that something had to be done. And within 6 months, the Voting Rights Act was passed and enacted. It has been reauthorized over and over again in 1982 and again in 2006. And each time with overwhelming bipartisan support, as Wade Henderson has already suggested. Today, for the first time in the history of the Voting Rights Act, only one Republican was willing to vote to even have a debate about amendments to the act. Now, why do we need the amendments to the Voting Rights Act? Wade Henderson has already well described what happened in 2013 in the Shelby County versus Holder decision. What needs to be said is that the preclearance provision that was gutted by the Supreme Court in 2013 was widely regarded as the aspect of the Voting Rights Act that made it the most successful, consequential, and effective civil rights statute ever enacted, because it allowed us to get at voting discrimination before it happened. The preclearance provision required that jurisdictions that had a history of discrimination had to submit voting changes to a federal authority to determine whether those voting changes were discriminatory before they were allowed to be enacted. And that provision stopped from going into effect provisions that would have disenfranchised Black voters, Latino voters, Asian American voters, Native American voters for the entire life of the Voting Rights Act until 2013. As Wade Henderson has described, a wave of voter suppression followed the Shelby County decision when the Supreme Court countermanded the better judgment of Congress that had engaged in a year's worth of hearings and had accumulated a rich and robust record about ongoing racial discrimination in the country. And Black and brown voters have been paying the price ever since. We've been pushing for an amendment to the Voting Rights Act to deal with this decision since 2013. And the John Lewis Voting Rights Advancement Act is the result of this effort. It is the result of the effort to create the updated formula that the Supreme Court asked Congress to create. What does it do? What does this updated formula cover? Well, it would now restore preclearance back to those jurisdictions that over a 25-year period have had 10 violations at the state level of the Voting Rights Act or of the Constitution, and 15 violations, including all jurisdictions in the state. 3 violations for county and local jurisdictions. It also includes preclearance for those jurisdictions that attempt to enact what we call known practices, those practices that have the tendency to result in discrimination. And that includes changing the method of voting from district elections to at-large elections, changing jurisdictional boundaries, changing the documentation or qualifications required to vote, changes in multilingual voting materials, and other known practices in jurisdictions where the voting age population is at least 20% of a racial minority. When the Shelby County decision was enacted in 2000, was articulated by the Supreme Court in 2013, the court reassured us that the Voting Rights Act was still strong because we still had Section 2 of the Act, the provision we use to challenge vote denial and vote dilution. But this summer, in July, the Supreme Court announced its decision in a case called Brnovich versus Democratic Party of Arizona. And in that case, the Supreme Court weakened Section 2, creating its own standards for the review of Section 2 cases, standards that had previously been written by Congress as Senate factors in the legislation that covered the amendment to the Voting Rights Act in 1982. And so this John Lewis Voting Rights Advancement Act, in addition to restoring a preclearance regime for jurisdictions, also would restore the severely weakened Section 2 of the Voting Rights Act and provide once again Congress's guidance on the relevant factors that courts should consider in determining whether a voting change violates Section 2. It would establish notice and transparency requirements that states must comply with when making changes to voting laws. It would establish a preliminary injunction standard. It would address the Supreme Court's famous or infamous Purcell decision, which has created a blanket prohibition on voting changes close to election periods. And it would establish new federal offenses and criminal penalties for officials who refuse to tabulate and count validly cast votes. And it adds an offense for conspiracy for interfering with the rights of voters secured by the Voting Rights Act. It would also establish new prohibitions against those who intimidate, threaten violence, or commit violence against election workers and poll workers. We have seen this proliferate throughout the country over the last 10 months. I'll close where I began, with the bipartisan nature of this bill. This is a democracy bill. Democracies, healthy democracies, want their electorate to vote and participate in the political process. The patron saint of the Republican Party, President Ronald Reagan, when he signed the reauthorization of the Voting Rights Act in 1982, said the following: "For this nation to remain true to its principles, we cannot allow any American's vote to be denied, diluted, or defiled. The right to vote is the crown jewel of American liberties." Today, 48 senators turned their back on the crown jewel of American liberties. This is a threat to our democracy, and it cannot stand. And that means that now the Senate must confront what stands in the way of the passage of this bill and the Freedom to Vote Act, and that is the filibuster. No Senate rule, particularly a Senate rule with the history of interfering with the civil rights legislation that would have protected Black Americans dating back to the late 1800s, should stand in the way of the ability today of Black and Brown and Asian American and Native American people to exercise full citizenship by participating equally in the political process. This is a moment for American democracy. Today it failed the test, but it can still pass the test. The filibuster must be confronted, it must be overcome, and we must have the John Lewis Voting Rights Advancement Act.